So with that, my name is Megan, and you've heard Adam and hopefully can see Adam. We are both barristers at Park Lane Plowden and would like to thank you for coming along this afternoon to our personal injury case law update. Adam and I, in preparation for this, have scoured Westlaw and other websites to find some interesting updates for you. What I can tell you is that on Westlaw for 2024, there were 105 cases covering personal injury and clinical negligence. They are obviously only the reported cases that have made their way to Westlaw, and there are many, many more. We will not be covering all 105 because, frankly, we would be here for about a week. So Adam and I have chosen a few cases which we think are interesting and have helpful reminders on personal injury practice and procedure. One of the cases we won't be talking about, that judgment was technically delivered in 2024, was the Supreme Court's decision in Paul, Palmer and Purchase. And that was the secondary victims judgment that came out, I think, on the 11th of January. And Paul has been well covered, certainly by us at PLP and many other chambers, so we won't be rehashing the secondary victims stuff from Paul. What we will be doing, though, is covering broadly these 5 topics. I'm going to take the first 3 and Adam's going to take the last 2/3. So we'll do something about road traffic accidents, a bit on fatals and a bit on procedure. And then Adam's going to take over to talk to you about cases with EL and PL elements and the thing which seems to be on everybody's mind at all times, fundamental dishonesty. So I'm starting with the case of Hassan. It's the Supreme Court case, which was about whiplash and non-whiplash injuries. And starting relatively straightforward, this will only apply to those of you that do any tariff work, but it's something that really we should all be aware of as to how the courts are thinking about totality of quantum of injuries. This case addressed the whiplash injury regulations, which have some very low figures for whiplash injuries. The court was asked, how should we give it a figure for general damages when we've got a whiplash on a non-whiplash tariff? And 3 approaches were put forward. The first was you do a tariff award, let's say £240, and then give an uplift for any additional pain, suffering, loss of amenity, which must be on top of the tariff award. If there's any crossover, you don't get an uplift. That was the defendant's case. Claimant's case was approach 2, that you give a tariff award, you add PSLA for the other injuries, and you don't give any deduction because the tariff is supposed to only compensate for your whiplash injuries. Or there was a third approach, which was the claimant's secondary position, which is you take the tariff award, say 240, plus your general damages for something like a rib fracture, say £2,000, and then you think about a deduction for an overlap. The Court of Appeal said, we like approach 3. That seems to be the most fair. And the defendant appealed and said, we don't think that's right. The claimant also cross-appealed. And so this case went to the Supreme Court. And the Supreme Court also accepted approach 3, which is tariff plus other PSLA and then make a deduction for totality. Now, I hope I've not lost those of you that don't do any tariff work right at the very beginning, because my intention was to use this case as a helpful reminder about the case of Sadler, which is regularly quoted. And in Sadler, what the court said is it's always necessary to stand back and consider whether there should be an uplift or a reduction for general damages in order to properly reflect the combined effect of all the injuries upon the injured person's recovering quality of life. So in other words, we must always think about totality, and it is not just something we should think about, it is necessary for us to do so as personal injury practitioners. And what the court said back in Sadler in 2011 is in the majority of cases, an adjustment and occasionally a significant adjustment may be necessary. That's certainly my experience and indeed my approach when valuing generals. in quantum advices and thinking about when we go to trial, because more often than not, judges are standing back and making a reduction. So case number one is our reminder to not be too generous, particularly when we're thinking about Part 36 offers. Case number two, stilling my heading of road traffic accidents, I've chosen the case of Atkinson. The reason I chose this case is, as we will work through, it involved a child claimant. The claimant was a 7-year-old girl who was involved in a collision with a HGV vehicle driven by a professional driver. The claimant was crossing the road very close to the mouth of a junction after school. She was crossing with her friend and her friend's mother, and she suffered very serious injuries requiring prolonged hospitalisation. So it was a significant case. The facts of the case are that the defendant had previously been speeding along the previous main road, and he turned left into a junction. But when he did so, his speed, it was accepted by the judge, was between 11.2 and 11.8 miles an hour. And at this point, there was a 20 miles an hour speed limit. What happened is the claimant collided with the near side of the lorry and the wheel went over her legs. She suffered really nasty injuries, including multiple fractures, degloving injuries to both her legs, and she required prolonged hospitalisation, as I said. In this case, she wasn't in the path of the defendant lorry, but rather she had stepped out into the road and collided with the near side of the lorry. So she wasn't in front of it. One might say the lorry didn't hit her, she hit the lorry. The defendant said that he was unaware of the claimant, her friend, and the friend's mother, but he saw a flash in his mirror, braked immediately, and he came to quite an abrupt stop because of his speed. The question for the court was, did the defendant's driving fall below the standard of a reasonably competent and careful professional driver? The answer was no. The court gave judgment for the defendant. I use this case in the update. It might feel shocking to say that a 7-year-old girl who was crossing the road on her way home from school did not recover compensation for all of her injuries. But what the judge said is, I have to look at all of the evidence. I have to look at this objectively as to whether the defendant's driving was negligent. There were 5 lay witnesses who said they did not consider that the lorry had been travelling too fast around the corner. One of the witnesses was from the vehicle behind the lorry, who said she had no cause for concern over the standard of the driving at any point that she had been following the lorry. The judge said there might have been a degree of inadvertence because the driver did not see the claimant prior to the accident. However, that failure must be seen in the context overall. And that context is that as he was turning left through the mouth of the junction, he was focusing on the road ahead. And overall, he was driving with care and attention. The judge also found there had been no obligation for the defendant to stop at the mouth of the junction. And finally, it was not foreseeable that either of the girls would step out or jog into the road at the moment when they did. We find this a bit uncomfortable, I think it's fair to say, probably for all of us, because the claimant was 7. The Highway Code also now says that drivers should give way to pedestrians crossing the road when they turn through a junction. Both of those things are true, but it's also right that we don't just focus on the actions of the claimant, we focus on the actions of the defendant. And so the judge said there were no measures which a reasonably prudent professional driver was required to take to prevent this accident. In other words, it was just that. It was an unfortunate accident. The judge also went on to say that a reduction of speed would not have prevented the accident. And the only way in which it could have been avoided would have been for the defendant to stop his vehicle. And the judge had found there was no obligation for him to do so. And that's why in this particular fact, we think about a young child, we think about them stepping out, but she wasn't in the path of the lorry. She stepped into the lorry as it was passing by. The judge then went on to consider contributory negligence in the event he was wrong about primary liability, and said that the 7-year-old girl would not have been contributory negligent if primary liability had been established. It's got in Atkinson some useful passages about contributory negligence for children. It's got some of the useful reminders of the historic cases where children of 8 or 9 years old are not held to be negligent in their actions. So it's a really good reminder when we're dealing with child cases of two things. The first is we like to think it's just not children's fault. The person driving the vehicle must be at fault. But we do still need to be analytical in our thinking about reasonableness and negligence. And the second is, if we establish primary liability, the younger the child, the less likely they are to be found to have contributed to their own accident. Case number 3. We're whipping through these, so we'll take this one slowly because you will see there's lots of initials on the screen here. This is the case of Yordanov. The reason I've chosen this case under the road traffic accident section is it is from a road traffic accident, but it's about what we do when there are multiple nationalities involved or applies to an accident abroad. Now, you'll have to bear with me. It took me a long time to read the start of this judgment to work out who all of the different initials were, because this was a road traffic accident in England, but it involved Bulgarian nationals and a Bulgarian car. The facts of the accident are that car 1 was behind car 2. Car 2 decided to overtake. Now, the people in the vehicles knew each other. They started racing down the street. And as the overtaking vehicle was finishing the manoeuvre, an oncoming vehicle appeared. On our list, that's car 3. So there's an overtaking manoeuvre. It's almost finished. There's a bend and an oncoming car. And the overtaking car tries to come back across onto the correct side of the road. And as it is carrying out that manoeuvre, it makes contact with the oncoming vehicle and probably also the vehicle behind. This was a really nasty collision because the passengers and drivers in car 1 and 2 were very badly injured. And the driver of car 2, in fact, died from the injuries. One of the vehicles also collided into car 4, but that was a stationary car. We've got lots of cars and lots of people. Car 1 was driven and owned by a Bulgarian national. The vehicle was both registered and insured in Bulgaria. Car 2 was being driven also by a Bulgarian national with 3 Bulgarian passengers. But car 2 was purchased in the UK and insured in the UK. Now, I haven't gone into detail on the slide, but there were 2 claims that presented themselves for the purposes of this action before the court. And they were to do with the driver of one vehicle suing the driver of the other, and also a passenger bringing a claim as well. So that meant there were multiple parties. In one of the claims, there were 5 defendants. And in particular, the 5th defendant, for one, was the Bulgarian insurer. And so an issue arose as to whether this case should be dealt with under English law or Bulgarian law. The case had already been issued in the English court, but the English courts can be asked to apply international law in their considerations. Rome 2 is our answer in Article 4. So Rome 2, Article 4.1 says, unless otherwise provided, the applicable law shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred. So that tended to suggest English law. Subsection 2, however, where the person claimed to be liable and the person sustaining the damage both have their habitual residence in the same country at the time when the damage occurs, the law of that country shall apply. Now, we'll all remember that car 1 was being driven by a Bulgarian driver, and car 2 had all Bulgarian passengers. So there was a dispute as to whether this was met and whether all parties had habitual residence in England or Bulgaria, and the decision was it was in Bulgaria. And that was for reasons such as both the driver of car 1 and the passenger in car 2 had families in Bulgaria, owned homes in Bulgaria. They were seasonal workers, so hadn't consistently worked in Bulgaria, but they had very strong connections and would travel back and forth due to their work. At the time, the reason that all these people seemed to know each other is that they were working on some sort of holiday camp and living there at the time as well. But that was in the UK. So once it was determined that both had their habitual residence in Bulgaria, that seemed to be the answer. But 4.3 says, where it's clear from all the circumstances that the tort is manifestly more closely connected with a country other than that indicated in either paragraphs 1 or 2, the law of that other country shall apply. Now, in our case, fortunately, we're not talking about a third country, but because paragraph 2 was answered in the affirmative, both had residence in Bulgaria, the question is, could that be overruled? And was the case more manifestly closely connected with England and English law? The answer to that was yes. So paragraph 64 is something I've flagged in the case of Yordanov because there onward, the court does a very thorough analysis of the considerations that we need to be thinking about when we have accidents abroad or accidents involving other nationals. The driver 1, passenger 2 were both Bulgarian nationals, but because of Article 3, the court determined that the centre of the gravity of the case was very much in England. This happened on English roads, involved some English cars, so that was the oncoming car, the other car involved in the main collision, and car 4, which was the parked vehicle. The immediate damage occurred in England, and it was English emergency services and indeed medical care that was provided to all parties for a number of weeks. I think the passenger was in a coma for a few weeks. And so what the court said is when considering the objectives of foreseeability and predictability, which the court must consider, I am unable to conclude in all the circumstances of the case that the legitimate expectation of the driver and the passenger involved in the case, following a multi-vehicle, multi-party road traffic accident that occurred in England, where they both lived and worked at the time, could have been that Bulgarian law should apply. On the contrary, the legitimate expectation would have been that the consequences of the collision would be governed by the law of the country in which the accident took place and in which they both lived and worked. I think it's a really helpful reminder to us that it's not as straightforward as A, where did the accident take place, or B, who is involved. It is more complex, and there is more of analysis required as to which law ought to be applied. Fatal accidents. I've chosen the case of Price for my update. I've only got one for fatal accidents because there weren't many published judgments on fatal accidents in the last 11 months or so. But this one was particularly interesting. And that's because P, who was a chef, tripped at work and sustained soft tissue injuries, relatively innocuous accident and innocuous injuries. Unfortunately, Mr. Price developed sepsis and he died 5 weeks post-accident at the age of just 60 years old. At first instance, liability was found in the claimant's favour, and so the defendant appealed the liability decision because of the causation effect of the sepsis. They weren't disputing primary liability per se of breach of duty and causation of soft tissue. But in this case, the claimant appealed quantum, and that's why I've chosen it for when we're thinking about calculating losses from fatal accidents. So in terms of causation, the appeal court said yes, the defendant is still liable. It's a good bit of the judgment if you do have a case like this where there's an initial injury and then a deterioration. Price might be a good one to go back to, but I'm not going to cover that in detail now, nor am I really going to cover issue 1, which is the claimant's first element of appeal on quantum. In brief, what happened there is Mr. Price was obese, and it was accepted that there ought to be a reduction in his but-for life expectancy. So had he not died from sepsis and from this accident, for how long would he have lived? The claimant's expert said there needed to be an 8-year reduction on the statistical life expectancy. The defendant's expert said there should be a 10-year reduction. The judge said he preferred the claimant's evidence. And so one might think that answers that, it's an 8-year reduction. But what the judge did is said, I prefer the claimant's expert. However, I think it's a 9-year reduction, which was coincidentally in between the two, the claimant and the defendant's evidence. And so the claimant appealed and said that's simply inconsistent. You can't prefer one expert, but then not adopt their opinion without good reason. And the appeal court agreed and said that this was an inconsistent decision. The judge's decision, they said, cannot reasonably be explained or justified. And so the lesson that I took from this case of Price on issue 1 was that we really should be expecting reasoning to be present and consistent when judges are determining which expert they prefer on which or a number of issues. And if we don't have that reasoning when we get our draft judgments or at handing down of judgment, we are entitled to ask for clarification to understand that. And if that decision cannot be reasonably explained or justified, it might open the door to a successful appeal. But the main issue that I wanted to share in terms of Price and fatal accident is the issue about quantifying financial dependency. It might be of some surprise to some of you that as a barrister, I say, I quite like maths. Not many barristers do, but I'm quite happy and taking the Ogden tables and doing some calculations. I've always been happy with a calculator. And so I find financial dependency personally probably a little less overwhelming than other people. And when I give talks at other firms, a lot of people get very nervous about the Ogden tables and calculating future financial dependency. I think the reason is that the numbers can be really big and sometimes people doubt themselves. But actually, what we'll see from Price and the judgments contained within is that it's not as scary as it needs to be. Just don't do what this judge did, because the issue was about financial dependency in a fatal accidents case. Both the schedule and the counter schedule of a loss adopted the conventional approach for a fatal accidents case of a 1/3, 2/3 approach, i.e., when you have a married couple, as Mr. and Mrs. Price were, what we expect to happen is they pool their income, but Mr. Price will reserve 1/3 for himself and put 2/3 into the pot. That's our conventional approach, and it changes if there are children under 18 involved to a 25%, 75%. So it's accepted as a conventional approach that the deceased would probably have reserved 1/3 of his income. That's a calculation that we can very easily do. We add both Mr. and Mrs. Price's income together. We take 2/3 and then we take out Mrs. Price's. However, Mrs. Price was on benefit at the time of the death, so she wasn't earning an employed income, she was on a benefit income due to ill health, and Mr. Price was her carer. After his death, her benefits had increased over time. There was quite a number of years that the benefits increased, and this came out in cross-examination, because what the claimant had done is presented her schedule of loss with the income she had at the time of Mr. Price's death. But on cross-examination, she accepted, well, my benefits have increased somewhat. And the increase was about twofold. So from about £300 net per month to about £600 net per month. And notwithstanding the defendant's counter schedule had adopted a very conventional 1/3, 2/3 approach, had adopted the benefits that she was receiving at the time of Mr. Price's death. In written submissions, the defendant said that a calculation could not be accurately reached because there was a lack of evidence about the exact figure of these increasing benefits. And so the defendant said to the judge that the conventional approach should be departed from. And instead, they suggested something like taking the conventional calculation and deducting something in the region of 10 or 20% to acknowledge that it was an imprecise calculation. However, what the judge did is didn't accept the claimant's approach, didn't accept the defendant's approach, and instead calculated the difference between the claimant and her deceased husband's weekly net earnings and said, well, that difference is £10 a week, and elected to say that that was the law. It's quite a confusing part of the judgment. And indeed, the appeal court says that. What I will say here is the appeal court are sympathetic to this judge. He had an awful lot of issues to consider. There were multiple hearings and there were multiple written submissions. But nonetheless, the judge happened is on this issue, the appeal court criticised the judge's approach and the figures he arrived at, saying that the point of our actuarial and statistical tools, such as those based on the Ogden tables and the 2/3, 1/3 rule of thumb, is that they counterbalance the uncertainties that would exist in a single case were it to be looked at in isolation by averaging over countless examples from other similar cases in order to produce a result which is reliable, notwithstanding the uncertainties of the case itself. So what the appeal court said is, let's not forget, we use statistical and actuarial figures as a happy average of things. We know this isn't precise. We know we don't have a crystal ball, so we have to do our best. And ultimately, the appeal court said, if the judge had stuck to the conventional 2/3, 1/3 calculation based on the figures at the date of Mr. Price's death, he did not have to concern himself with these later increases in the benefits unless they truly represented a departure from the ordinary run of circumstances. And so no such departure was evident on the evidence he heard. So that is another helpful reminder for us that when we're dealing with fatal accidents cases, the losses crystallise at the point of death. And we are entitled to use the actuarial tables and statistical figures and trust that they represent such an average that these fluctuations in income are accounted for, unless there are such exceptional circumstances where that approach is to be departed from. And so on to my last section of my bit, it's about procedure, everybody's favourite bit. Procedure to me means these applications that we make, it means the process, and it's the running of the case rather than the outcome itself. So I've got just two cases on procedure which we will whip through before I hand over to Adam. The first is Clark and Poole. This was a very serious road traffic accident and pleaded at over 22 million. In this case, the claimant's mother was diagnosed with an asymptomatic myotonic dystrophy disorder. In other words, she suffered from a genetic disorder which caused a progressive muscle loss and weakness. This was important because the claimant's injuries were cognitive and physical impairment, but weakness in the right upper and lower limbs with spasticity, which impacted her balance and her mobility. She also had memory issues and mental flexibility difficulties in processing, and she suffered sleep disturbance, fatigue, pain, and psychological problems. So part of her future care claim, which was about 15 million of that 22, involved issues which would overlap with this type of MD disorder because it was muscle weakness. And so what the defendant argued is, well, her mother has this condition, albeit the mother is asymptomatic. It's a genetic condition. And so the defendant said, well, the claimant would have developed symptoms from MD herself, and she would therefore have required substantial care in any event. Rather than just having this dealt with on expert evidence, what happened is it wasn't known whether the claimant had the MD gene. So the defendant sought a stay in proceedings to allow the claimant to undergo neurophysiological testing to determine if she had the gene because the claimant's case is that he didn't. Court in considering whether to stay. The first is, was it in the interest of justice for the testing to be carried out in the first place? This is neurophysiological testing that the claimant would have to undergo in order to determine if she carried this MD gene. The answer to that was yes, it was. Step 2, whether the claimant had put forward a substantial objection which was more than imaginary or illusory. The answer is yes, she did. So it all came down to step 3. The court had to balance the parties' competing rights. So the defendant's right to defend themselves, but the claimant's right to her personal liberty. And overall, the court determined that the stay ought to be granted. But in order to balance everything appropriately, a blanket stay in proceedings was not just. Neither was a blanket stay in proceedings on the entirety of her future losses, but rather the court said that the future losses that might be attributable to the MD, those losses are stayed, but any other care claim which would arise above and beyond that, i.e., the care claim which the defendant accepted on its own case, even if the claimant had MD, would be established, that should be allowed to proceed. The court said, it does not seem to be just that the claimant should be entitled to pursue her claim in full if the defendants are deprived of the opportunity of carrying out tests which will identify whether or not she has active symptoms of MD. And so the court considered things like the harm to the claimant, so the physical risk of the testing were quite modest. There would be therapeutic advantages if the testing was answered in the affirmative. Any of the claimant's anxieties about the testing could be alleviated with certain measures. And indeed, the claimant was not compelled to undergo the testing. The court didn't order that she must be tested. The court simply stayed the relevant part of her claim and said that if the claimant would like to bring her claim for these vast future losses, that's what she must do. And so that element of the claim was granted in favour of the defendant and was stayed. And then my final case on procedure connects to some of the more exciting fundamental dishonesty cases you'll hear about from Adam. It's Mahmood. This was a road traffic accident where the claimant suffered a significant brain injury and he had a litigation friend in the case. Primary liability was admitted, but both contributory negligence, causation, and quantum were all in dispute. So much so that the defendant had alleged dishonesty and was seeking that the claimant's case ought to be dismissed pursuant to Section 57. The claimant, on account of the seriousness of injuries, applied for an interim payment of £75,000 to fund his rehabilitation and treatment. His case was that he could no longer manage the restaurant he owned. However, the basis for the defendant's case, and there is a typographical error in my last point, it's that the defendant had surveillance evidence showing the claimant still working long shifts at his restaurant. He was opening and closing the premises, and he was interacting with customers. So the defendant was saying that they had surveillance. The content of the surveillance was not disputed, and it was accepted that this issue was an issue that required determination at trial. And so the claimant, when they applied for an interim payment under CPR 25(7), was required to establish any of the following conditions in subsection 1, primarily 1A, which is the defendant against whom the order is sought has admitted liability to pay damages or some other sum of money to the claimant. The court very clearly said no. And by virtue of the fundamental dishonesty plea that the defendant has put in its defence, the defendant has denied liability to pay damages to the claimant, and it seeks dismissal of the claim. The court said that is the short answer to the application. The claimant tried to use subsection C and said, well, hang on, if we go to trial, what if the court is satisfied that the claimant would obtain judgment for a substantial amount of money? The court said no, it's the same consideration. The defendant has raised fundamental dishonesty, and this can only be determined by trial. It's not appropriate for the weight of such a Section 57 application to be determined at an interim hearing. And so I end on this case because fundamental dishonesty rumbles on for all of us, whether you're acting for a claimant or acting for a defendant. But if you have a seriously injured claimant, and if you are considering an interim payment and making that application, Mahmood is unfortunately the very short answer to that application, which is if dishonesty is pleaded, either as a dishonest claim or indeed a dishonest claimant, then the short answer is you're probably not getting your interim payment. So thank you for sticking with me for the first half an hour of our talk. I'm going to hand over to Adam now, who is going to talk to you about these three things, EL, PL, and fundamental dishonesty cases.
Thank you very much, Megan. While you were talking about price, and I say this not just to prove that I was listening throughout the half hour, it reminded me of the first time you and I encountered each other in a professional context, and it was in a small claims hearing wherein there was a discrepancy of about a penny somewhere along the line, and you announced with great pride that you'd worked out exactly where it came from. So to the extent that it's necessary, I can confirm your mathematical rigor. Having started with that nice anecdote, I then I suppose I have to offer a mea culpa that in terms of ELPL cases, there aren't actually all that many of interest within the last sort of 12 months. So I've taken a slightly more, well, within the year 2024, I've taken a slightly more generous approach. And of the 105 cases that Megan outlined were on Westlaw, I've taken 108 and 110. The keen-eyed amongst you might notice that that's December last year, but I'm sure we can get away with it. So the first case that I want to talk to you about is the case of Benion. That's on screen now. So this is one of those decisions from the end of 2023. And this ties in to a certain extent with something Megan said in relation to one of the road traffic accident cases, because this is a case in which the claimant was seriously and life-changingly injured surfing at a specifically designed lagoon at the defendant's premises. It's quite difficult to get a flavour of precisely how the thing was designed, reading the judgment and without access to the papers. But suffice to say, it appears that surfing activities were divided across 4 categories: beginner, intermediate 1, intermediate 2, and advanced, and that those different skill levels were placed at different points around this lagoon. And the reason it might appear to be a surprising decision that the defendant was found not to have breached the duties that they owed to the claimant was, as you can see from the fourth bullet point there, the defendant had failed to consider guidance about the recommended minimum depth. Now, it was indicated by expert evidence and historically that the recommended minimum depth for the lagoon was a depth of about 1.5 meters. The point at which the claimant had his accident, the claimant having been categorized as an intermediate 2 surfer, was close to a reef which had been designed into the lagoon, at which point the depth was only 0.9 meters. And against that backdrop, and particularly in a scenario where the claimant was so significantly injured, in fact, he was rendered tetraplegic by this accident, one might have naturally assumed that there would be a sympathetic eye cast towards the claim and for it to succeed. But in fact, it didn't. And in part, that is due to a need to balance certain factors. The first is that there is a social utility to allowing people to engage in leisure activities and to not take an unduly prescriptive and paternalistic approach to their administration. Secondly, even though on the defendant's own risk assessments prior to mitigation, the risks that were potentially caused by somebody having a similar accident were expressed as being high. It was calculated mathematically that the usage of the lagoon was such that it basically translated to someone having been surfing there, 1 person per day for a continuous 24-hour period for a period of about 20 years, and no similar accident had been recorded. And when one digs in a little deeper to the realities of how this accident could have been completely avoided. Part of that would have been to have removed the reef, which would have made the design of the lagoon impossible and would have prevented surfing there, or to have removed a category of surfers to allow that particular area not to be used. But that might have in and of itself created a different risk, because people would have to go from a lower category to a higher category without an intermediary step, and that might have created its own risks. What the defendant had done well, and it appears the claimant accepted in evidence, was make him aware of the depth of the water, and the court went so far as to find that there was no requirement on the defendant to explain specifically to the claimant how to fall off the surfboard safely. The observation is made that I'll call it a risky activity, in the sense that there are other similar types of activities, but unlike, and I think the examples that are used are mountain biking and skiing, it's almost inevitable that someone will fall off a surfboard, whereas obviously the operative point of being on a mountain bike or being on a set of skis is not to fall off. But here the defendant had required the claimant and any other user to self-certify as to their abilities, and that meant that they weren't required to go so far as to actually tell him how to fall off safely. Now, that generalized conclusion is summarized in the final bullet point that I've drafted on the slide there. And I've done this on a couple of slides, and the reason that I've done that is because I've tried to, where it's appropriate, doesn't do it on every slide, but if there is a takeaway from the case that perhaps if you come back to look at these slides at some later point and you need to see it at a glance, there is a pithy one-line description of what needs to take place. I'm flagging this to everyone's, or bringing this to everyone's attention, because at some point a little later on, I have taken a quote from a film, and I wouldn't want anyone to try and cite that as any actual legal authority. It's just there as a reminder to you and to me. So that concludes Benny. And Megan, if we move on. Yes, Robertson now. This is the slide which ends with a quote from a film, about which I will talk shortly. This is a relatively recent decision. In fact, I think it's within the last sort of month or so. Broad circumstances are the claimant is out on a bike ride with his wife. His wife is cycling in front and the claimant is cycling behind. That's of some relevance in the sense that because his wife was cycling in front of him, there were no direct witnesses to the accident and who could directly speak to precisely what it was that caused the claimant to fall from his bike and to suffer a significant head injury. What this case appears to boil down to is that it is suggested that the underlying design of the transition point between a cycle path and roadway appears to have been unsafe, rather than having been a failure to maintain, as might more commonly be seen in Highways Act cases. The reason why I've put this in, notwithstanding that there is some helpful discussion, and we'll talk about this in relation to Stokes as well in a couple of minutes' time. There is some useful discussion of circumstances in which the court can use reasonable inferences or deductions of logic to ascertain precisely how an accident happened in situations where there are either no witnesses at all or no witnesses who could see. But the reason why I've put this in is because there's a salutary lesson to us all here that quite often, and whether one is acting for claimants or defendants, particularly perhaps in road traffic accident context where the defendant is an individual policy holder, there is very often a case or a situation where parties feel very strongly about their case or about defending the case that's been brought against them. And sometimes that, I'm not suggesting that's what's happened here, but there is something can be taken away from it. Sometimes the strength of that belief sort of ends up compromising the evidence gathering process, because the trial judge in Robertson, for reasons of which aren't entirely clear and I wouldn't like to venture, but had photographs of the purported defect itself, but didn't have any measurements against which to contextualize it and to make a determination of whether or not that represented a hazard and a potential mechanism for the claim having fallen. So I've put in this final line, which is, it's not about what I believe, it's about what I can prove. And I've stolen that wholesale from the script of A Few Good Men. I make the anecdote at this point that I put this in a slideshow presentation a few years ago that I did to try and educate people about the Ministry of Justice portal for road traffic accidents and the need to upload appropriate evidence and the importance of stage 2 of that particular process. And I drafted a very detailed slideshow and I included this quote in it. What I didn't factor in to that was that was a presentation that was primarily being given to relatively junior staff members who had all been born after A Few Good Men was released. So I'm sincerely hopeful that a second time of asking, somebody will at least get this reference this time. I also, please, if there is one takeaway from this, it's do not quote Tom Cruise as any kind of legal authority. This is just an aid memoir to you to try and ensure that some kind of takeaway can be drawn from this case of Robertson. So if we move on to, I think it's Stokes next, Megan, thank you very much. Again, the underlying factual matrix here, and this is where there are some parallels to Robertson, it is somewhat complicated because the precise mechanism of what it is that caused Mr. Stokes to fall is unknown. It was a scenario in which he was employed by the Ministry of Justice. There's a second defendant, which I think is Amy, who were the maintenance contractor who were involved. But Mr. Stokes was employed at a prison. At some point, he needed, over the course of a night shift, to descend a set of stairs. Something happened to him, and he was found unconscious at the foot of those stairs. The reason I've included it is as a case that from which lessons can be learned is the interrelation of two defendants, particularly where one is an employer and one is a maintenance contractor, is something that comes up regularly, commonly, and often where there are multiple defendants, there will be a desire to say, well, this obviously isn't us as the employer because we have a contractor, and the contractor will say, well, this obviously isn't us because we're not his employer, and that's a non-delegable duty to keep him reasonably safe. The judgment here apportions liability between the first and second defendant, ostensibly on the basis that the first defendant had failed to provide Mr. Stokes with a safe place of work and a safe method of access and egress down the set of stairs, and because they didn't have an adequate system for either identifying or for reporting defects. And the second defendant, who was 60% liable because they had adequately failed to repair the nosing on the stairs on which he fell. I trust you all can probably work out what I mean by nosing. It's the strips that people put on the edge of steps. There were some scathing criticisms made in judgment about the veracity and the accuracy of some of the checks that were being carried out by the second defendant, and it's perhaps worthy of note in an ongoing sense that the rigor with which these inspections and investigations are being undertaken is and can often be a factual determination which the strength of which can only truly be determined at trial, because one can imagine a situation where documentary evidence says, well, we went and checked this, we went and checked that, we went and checked the other, but without having the opportunity to test that evidence, then we don't truly know whether anything more than lip service is being paid to carrying out those investigations and checks. So that is an interesting case for more so for the mundanity of the interrelation between the two defendants than necessarily what precisely happened. So Megan, if we move on, I think I've briefly got some other notes. The only reason I've put another 2023 case in is in part, as the third bullet point says, to well, the final bullet point, should I say, is a reminder of the vagaries of defending employers' liability claims, because Mr. Manning was, by the judge's notation, an experienced employee who was doing something that was, by the sounds of it, inherently dangerous, in the sense that judge noted that it would be perceived to be unsafe, even viewed as a layperson. But still, there was 75% liability found against his employer for having not provided him with the specific materials to do a specific task. It sounds, if we read the judgment, to some extent to be a little esoteric and related to the fitting of square pegs in round holes or similar. But the reason I've put it in as well is this was an accident which happened, I think, shortly before, but the ongoing investigative process continued after and into COVID. And there was significant criticism made by the claimant of the defendant because they weren't able to inspect the lorry from which the claimant had fallen. Defendant's position was that it had been scrapped for reasons entirely unrelated and related to procedural and operational reasons, rather than having been put outside the tentacles of the claimant and to prevent them from inspecting or examining it. The claimant wasn't satisfied with that approach and it invited the court to draw adverse inferences from the fact that they had not been able to have a look at it and to investigate it. And I must say, when I was reading and researching cases to talk about in this case law update, I wasn't necessarily anticipating that I would find judgments which related to the destruction of evidence, but actually this is probably something that comes up not wholly irregularly within the sphere and scope of personal injury claims generally, but perhaps comes across an individual's desks maybe only once every couple of years. And I wasn't, again, necessarily expecting to see Rebecca Vardy and Colleen Rooney's names in the list of authorities that were cited, bearing in mind how Mrs. Vardy's phone apparently ended up in the North Sea at one point. But in any event, the overall conclusion here, despite the repeated attempts that the claimant had made to try and get an inspection, judge was satisfied that there were no adverse inferences that should be drawn, but that appears to have been slightly influenced by the fact that COVID was such a problem at the time that these communications were taking place. And it may well be that if this precise factual scenario were to manifest itself now, that a court would not be quite so forgiving and willing to not draw that adverse inference. So that is perhaps a discrete lesson that can be taken away from Manning, more so than anything procedural or substantive, and something that may pop into your head if you get a similar case cross your path or a similar issue cross your path in due course. That's all I really have to talk about in terms of employers' liability and public liability. I now want to go on to talk about FD cases a little bit more. And I've started by citing the text of Section 57 of the Criminal Justice and Courts Act, just so Again, if anyone happens to look at this slide and needs them as a reference point, that it is there. It is a piece of legislation with which I am sure you're all familiar, but at the same time, it's always handy to have it, particularly where within the list of authorities, there are occasional references to Section 57, but perhaps not that level of explanation. So it is there for reference if we need it. And so if we move on to the first case, Megan. Okay, the first decision I want to talk about is, as you can see from the slide there, Williams, Henry and Associated British Ports. This is a terrible sounding accident where claimant falls, it's estimated around 4 to 5 meters onto some rocks and suffers some genuinely horrific injuries. She has a skull fracture, a traumatic brain injury, a rupture to her left tympanic membrane, multiple pelvic fractures, and a trimalleolar ankle fracture. She also has, not unsurprisingly, some psychological sequelae as a result of the accident. Now, in the first part of her recovery, the claimant appears to recover rather well. She engages with NHS services and returns to, albeit on a reduced hours basis, what sounds like, at the very least, a high-powered and complicated job. She's described as a senior business analyst, and indeed part of the ongoing focus of the case was in terms of Ms. Williams Henry's potential earning capacities and how they had been impacted by this accident. But at some point, there ceases to be engagement with NHS rehabilitative services, and the claimant begins to utilise interim payments to undertake alternative rehabilitation avenues and strategies. It's not immediately clear what the driver is to do this, but the defendant's concerns, the defendant begins to express concerns and has her surveilled. The thrust of judgment it reads fairly scathingly of the claimant. In fact, in one paragraph, Judge goes so far as to say, the burden of proof lays on the defendant. I consider that it's been satisfied by the defendant in relation to the specific findings of the lies that I have set out above. These covered conscious gross exaggeration and fabrication of the true duration and stroke or extent, inter alia, of hearing loss, disability, noise intolerance, dizziness and balance issues, fatigue, lack of spatial awareness, ankle pain and range of movement, left-sided hand grip and alleged weakness, cognitive disability, memory and cognitive functioning, light intolerance, back of head pain, ability to shower alone, foreign travel, ability to socialize, ability to drive long distances, need for help with activities of daily living, and headaches. That was 19 separate factors in respect of which the court appears to arrive at the conclusion that the claimant was being dishonest. Now, what this goes on, or what the ongoing utility of this judgment, and you can see from the slide there that the genuine elements of the claim is worth around £600,000, but the dishonest element was around £1 million. The determination of whether dismissing the claim would constitute a substantial injustice requires a balancing act of various factors. It requires the court to undertake a comparison between the total amount claimed, the genuine element and the dishonest element. And you can see broken down in the preceding bullet points, the claim was originally for around £2.5 million. The genuine element would have been 600,000, and the dishonest element was around 1 million. So somewhere in the region of 40%. The scope and depth of dishonesty. Now, it's apparent here that the claimant, and judge actually goes so far as to say, to comment on this in the concluding stanzas of the judgment, that the claimant was in parallel seeking to defraud the DWP and also an insurance company about the level of her injuries. The cost consequences of the dishonesty, there's some guidance from this elsewhere in Shaw, I think, and to some extent that informs and will necessitate consideration of the way in which the evidence is and the progression and development of the proceedings is shaped by the allegations of dishonesty. So, for example, if a claimant brings a claim and is surveilled, obviously there needs to be analysis of the surveillance evidence. There will, in all likelihood, be a witness statement from a surveillance operative, and the case will take on a completely different trajectory and lifespan than it would have done if those elements hadn't been necessary. The scope and level of genuine disability and impact on other services, that is in a less delicately phrased sense, perhaps best viewed as the potential impact on the NHS if the claimant is going to require a significant amount of rehabilitative input, which cannot now be funded privately, for example. The nature and culpability of the underlying tort. I suspect that this is likely to be a consideration which is relatively rarely engaged, in the sense that without any underlying maliciousness to the tort, say, for example, in this case where claimant has fallen off a pier or a entirely accidental road traffic accident, then that is unlikely to be something that would trigger this trigger any consideration under this issue. Perhaps the only place it might is in relation to some form of abuse. And finally, the impact of dismissing the claim on the claimant's life. I've wrapped this up with whether or not any interim payments have been made and whether or not they would need to be repaid, because it seems that Judge at this point considered these things a little bit contemporaneously. A claimant had an interim payment of £75,000 here, and there was no application for it to be repaid. But at the same time, Judge would have, or appears to have made the conclusion that he would have not made such an order, because that might have had the effect of rendering the claimant homeless, jobless, depressed, and potentially suicidal. But in terms of the denial of her claim, this was ultimately packaged in the sense that the defendant, or the claimant, sorry, maintained during and throughout trial that she had been completely honest at all times, and appeared to show no repentance or remorse for what she'd done. On that basis, concluded that it would not be a substantial injustice to dismiss the claim, even though that represented a lot of money to deprive a genuinely injured person of. And that is something that that is consistent with the next case that we're going to talk about, which is, I think, is the case of Shaw and Wild, which, as the slide says, is understood to be the claim with the highest value genuine element, where a defendant has successfully engaged Section 57. Genuine element here in excess of 1 million against a pleaded value close to 6.5 million. A lot of the analysis is the same, but this gives you even further and even more clear guidance of how the court might generally approach a claim with a higher value element, but also provides us with a different frame of reference. It uses the analysis of the level of injustice the claimant would face if they had been left in a situation where, if I take you back a couple of minutes to my example of an entirely accidental road traffic collision, if it transpires that there was no insurance, and say for the sake of argument that the Motor Insurance Bureau doesn't exist, but a claimant could not afford, or the defendant, sorry, could not afford to meet any judgment, how unjust would the claimant, or how unjust would the situation that the claimant faced be in that scenario? And that is an insightful frame of reference to use going forward. The other reason why I want to specifically talk about Shaw is that the claimant, and this is perhaps a lesson which can be learned whether one has a claimant practice or whether one has a defendant practice, just in terms of a general observation. Claimant was historically a keen base jumper, which requires one to jump off very tall things with a parachute, if you're not conversant with what a base jumper is. His evidence was that he'd not been able to base jump as a result of his injuries, which were plainly significant. But the defendant managed to adduce surveillance evidence or social media evidence of the claimant looking very much like he had just carried out a base jump. And in fact, the court's conclusion was that he had. The lesson that I'm reminded of is something that a more senior colleague once said to me a long time ago about when I was involved in a case where the claimant had a relatively niche hobby that I think was called roller derby or something similar. But it was said to me that people who have more niche hobbies or hobbies that are on the extreme end of the norms of what people might be perceived to do, or also people that tend to be relatively active on social media, posting about this new and interesting thing that they have just done. So that is perhaps something one could bear in mind when one is either acting for or when one is in receipt of a claim brought by somebody who has a relatively unusual but physical sporting interest, perhaps. So if we move on to the next slide now, my notes have gone slightly out of order, but yes, Thakkar is the next one that I want to talk about. Thakkar is an interesting case because it also has or necessitates consideration of costs, which was a potential additional topic for discussion at this case law update. So I'm glad that we did manage to get some cost discussion in. It's a relatively straightforward factual scenario. This is a disputed road traffic accident. Claimant says a van was driven into his car. Defendant says that the claimant pulled out. So far, so normal. Defendant seeks to defend the claim and at first blush drafts a defence which puts the credibility of the claimant in issue without going so far as to actually say why, it appears, and appears to have been an attempt to potentially undermine the bona fides of the accident without actually going so far as to say this is the specific thing that we say that you've done wrong, and is consistent with a sotto voce approach to pleading fraud, which isn't the way matters should progress, but in respect of which there seems to be still an ongoing tendency amongst some defendant insurers. At some point before trial at a case management hearing, defendant seeks to amend the defence to actively plead fundamental dishonesty and to nail their colours to the mast. That permission is not granted, and it's fairly robustly dismissed, reading between the lines. I don't think Judge was desperately impressed with the request or attempt, but the reason why I'm specifically highlighting this aspect of the case is in the judgment of the Court of Appeal. Lord Justice Coulson, in talking about matters in relation to pleadings of fundamental dishonesty more generally, and noting that in accordance with the settled authority of Howland and Davis, that there's no specific requirement to plead fundamental dishonesty. There's a salutary reminder to all legal professionals and that these allegations should only be made in situations where they can be justified and appropriately evidenced, and a acknowledgement and a cognizance of the fact that one doesn't have to plead fundamental dishonesty to have it be found at trial shouldn't be taken as carte blanche to cross-examine and seek to call people effectively liars at trial without any forewarning in any scenario, which is a lesson which could and should be learned. Back to the costs takeaway, claimant's rather innovative approach was on operating on a line of analogy between the way in which matters proceed in chancery and commercial cases, where there is a presumption of costs on an indemnity basis in scenarios where allegations of dishonesty have failed. They said, well, we should be entitled to our costs on an indemnity basis from the point at which the defendant sought to allege fundamental dishonesty. The view of the Court of Appeal was that there is no such presumption in civil cases, and in fact, to import one would be to fetter the judge's discretion on costs and would effectively amount to a reversal of the burden of proof. If you just look at the bare facts of that, and I perhaps should have made the observation that I've just called it Thacker and Mecan, that the second defendant was Mecan's insurance company, which I think was AXA, so you may see it reported elsewhere as Thacker and AXA. It would appear, on first blush, it would appear that this is relatively positive news for defendants, but actually, and I think this has got to be correct and appropriate, within one of the later paragraphs of judgment, Lord Justice Coulson makes clear that a defendant who makes allegations of this kind that are unsuccessful runs a very significant risk of indemnity costs being awarded against them. And that is and does appear to represent an appropriate shifting of the sands that may assist in changing the practice of matters being defended in a matter which is broadly akin to an allegation of fraud that actually might not necessarily be perceived as that by claimant solicitors, and leaves the claimant in a situation where they arrive at trial and are told by counsel exercising their professional responsibilities that it's highly likely that they're going to be cross-examined and their credibility and the veracity of their account called into question. So that may, if I put my optimistic hat on, bring some clarity to the way some matters proceed going forwards. If we move on to the next slide now. Yes, it's just some other cases that I wanted to discuss. Megan's already talked about Mahmood, and there is also guidance on Chambers' website, or an article I think Corinne Furness wrote about this case, so I won't take up any more of your time. Other two cases that I did want to discuss, Sene and Mulzan. My apologies to the claimant if that's not how that's pronounced, but that's how it appears to me. It appears to be a resolution of a question which has vexed some of my colleagues in the past, and in respect of which probably represents a sensible conclusion. But what it is clarification that a finding of section 57 in a situation where a claimant has been dishonest about the presentation and development of an injury claim does not have the effect of extinguishing a genuine claim for, say, vehicle damages, as it was in this incident, arriving out of that accident. And there is a logical consistency to that. I know that I've had cases or discussed cases in the past where the view was taken, well, this claimant is lying about the injury, so why is it that he can still recover? But within the text of the judgment, there is some consideration of the underlying parliamentary process that introduced section 57, which makes clear that that was in fact never actually the intent of Parliament, to stop the genuine elements of those claims if they are not related to the PI claim. So that hopefully provides some clarity. I'm conscious that I've spoken for a little longer than I was actually intending to, which is consistent with brevity not necessarily being my strong suit. But I do want to finish off by talking about this final case of Wye Valley NHS Trust and Murphy. Sorry, I can't read my own writing there. This is a case which has attracted some general media publicity. You might think that the case name or the party names here are the wrong way around. They're not. This is an application made by the defendant for the claimant to be committed for contempt of court. Circumstances underlying are claimant suffers left bicep injury necessitating tendon repair by the defendant trust. He issues proceedings for it transpires close to £600,000 and receives an interim payment of £40,000. But as part of those claims says that he can't work, can't really use his left arm to the extent that he has difficulty dressing and has difficulty holding a saucepan, and stroke or play rugby. The defendant, contrary to what the defendant did in Thacker, gets their ducks in a row early and pleads section 57 within the defence. Not quite clear of the precise orderation of the next steps, but Mr. Murphy's solicitors come off record, and then thereafter, to borrow a increasingly common phrase, Mr. Murphy appears to try and quiet quit his claim because he basically doesn't do anything beyond the service of the defence. Unsurprisingly, defendant NHS Trust, having made an interim payment of £40,000, doesn't just want to let sleeping dogs lie now that they've discovered that in fact Mr. Murphy can play rugby and has seemingly no ongoing effects in respect of his left arm. There is a multi-day trial before Mr. James Heagley Pratt, sitting as a Deputy High Court Judge. He makes a finding under section 57 and dismisses the claim. And the reason why I've put this in is because often when whether one is acting for defendants who might be making allegations of dishonesty, or whether one is acting for claimants, one will have to give guidance or consider guidance about whether or not a finding of contempt of court is potentially indicated in circumstances where an adverse finding is made against the claimant. And the application for the contempt finding in this instance has some useful guidance about what the law of contempt is. Essentially, the applicant must prove beyond a reasonable doubt of the falsity of the statement, that the statement interfered with, or if it was continued with, would have interfered with the course of justice, and the maker knew that he or she was being dishonest at the point at which they made the statement and knew of the likely interference with the interests of justice. And if one applies those points here, then plainly the claimant would have known, or let's say the claimant, Mr. Murphy, would have known that he was being dishonest about his capabilities. Those dishonest elements would have impacted on the value of his claim, which would have been a natural facet of the course of justice, and that he would have known that by lying about what he could do and his capabilities, that would have had the effect of increasing the value of his claim. So the conclusion of the court was that, in fact, the claimant had been, or Mr. Murphy had been, dishonest in relation to all of those elements, and he was duly committed for contempt of court. There was one other final case that I wanted to briefly touch on, if one allows me the latitude to connect people who are dishonest with people who may have forgotten to MOT their cars, because not quite in time for us to talk about it in this hearing, but in this session, but the Court of Appeal hearing in Ali and HSF, which is all to do with whether or not failure to obtain an MOT certificate should have the effect of defeating a claim for credit hire, was heard at the back end of October. So it's likely that by the time, whether it's Megan and I, whether it's some other people from Chambers, by the time there is a next case law update, that might be something that we could talk about. I don't want to stick my head above the parapet and try and have a bash at what the Court of Appeal might say, because I don't want to have the effect of significantly outdating this webinar if it turns out I'm completely and woefully wrong. So I'll leave that there, but that's something to watch this space about. But thank you very much for your attention. If anyone is indeed still there and still awake, and thank you for joining Megan and I during this webinar.
Fabulous. Well, thanks so much, everybody, for joining us. Don't forget to put it on your CPD record sheets. If anyone has any questions or queries, do just get in touch with us. Our emails are on the slides, and we'll ask our marketing team if it's possible for us to circulate a copy of the slides too.